The EU Commission wants to give investigative authorities in the member states access to personal data from internet companies. The European Parliament passed a regulation on this in July 2021. The European Council still has to agree. European doctors are calling for the regulation to be changed. The title of the EU regulation that is being disputed is written in the finest official German, when you read it in my language, and reads accordingly bulky: Regulation on European Release Orders and Security Orders for Electronic Evidence in Criminal Matters. The political consequences of this regulation are highly explosive. The point is that telecommunications providers, cloud providers, and internet service providers should release their customers' data directly to the investigative authorities of other EU member states. For companies in Germany, for example, I'm talking about Germany because I live here, this would mean they would have to give their customers' data to investigative authorities in other EU member states, even if the act persecuted is not a criminal offense in Germany. For example, an abortion that is permitted here. For Professor Frank Ulrich Montgomery, President of the Standing Committee of Doctors of the European Union, the CPME, that's an absurdity. Then someone at Google or Microsoft will check the legitimacy of this request. In our opinion, this is not enough at all, because these companies are not in a position to meet the special complex requirements of medical confidentiality. For example, and what we consider to be the content of confidentiality, the conversation and the action between doctor and patient have to be considered as well. This regulation not only affects internet providers and telecommunication service providers, but also cloud providers who, for example, store patient files. Frank Ulrich Montgomery said about that, better legal precautions must be taken here to ensure that this data is protected in a special way, that it is recognized in a special way and immediately destroyed if it has nothing to do with the actual procedure or criminal liability. Therefore, improvements must be made here. And the European Council must now make this improvement. The European Parliament waved through the regulation earlier this month on July 6th, which I still don't understand. The approval of the Council is still pending. In its current form, we would love to have it rejected because we are not fundamentally against improved options for criminal prosecution and the gathering of evidence. We want to achieve changes in a number of essential points. These points primarily concern the special rights of so-called professional confidentiality holders in addition to doctors. That also means lawyers, pastors, and more like that. And we believe that this draft law does not go far enough. Rainer Wieland, Vice President of the European Parliament and member of the group of the European People's Party, thinks what Montgomery said is exaggerated. At the legal level, an attempt should also be made to understand what is otherwise normal in the EU. And he said, wherever the internal borders within Europe still play a role, there you have to try to overcome these internal borders. Surrender orders and search warrants, as well as the securing of electronic evidence, must also be able to be enforced just as efficiently at the European level as within Germany, he says. What happens if there is a victim in Stuttgart, a perpetrator in Düsseldorf, and the documents in Dresden? Yes, then you can manage that the public prosecutor in Stuttgart organizes it by issuing a surrender order or even by a search warrant in Dresden to get the relevant evidence. And nothing else can apply in Europe. Nothing else can apply in Europe, he said. But maybe they're talking not straight at each other somehow, because President Montgomery does not accept the argument. He says, because we have different levels of confidentiality declarations, different levels of the design of confidentiality, for example with doctors in different countries of the European Union. For these cases, a state examination must always be carried out at least on the other side. That means on the issuing side, and not the examination by a service provider whose interests are completely different from that of a court or a public prosecutor. If the European Council adopts the regulation, the doctors threaten to say goodbye to the upcoming digitization projects in the healthcare system. The electronic patient file, for example, would then be on hold for the time being. In the end, this leads to a contradiction that we can only resolve by saying goodbye to digitization projects and saying the European Union is directly hindering the digitization of the healthcare system, which, by the way, is very much wanted by us and which would be very important, Montgomery says. And I'm quite interested what the Council will do with the situation. And I'll see you in my next video. Bis gleich.